Good evening, everyone. This is a meeting of the Policy Subcommittee of the School Committee. This meeting is being recorded. We do have the chat function enabled for members of the public who would like to participate in real time. We will hopefully be able to address many of your questions, and there may also be opportunities for members of the public to be promoted to be able to speak directly to us. So the first order of business on our agenda today is a review and approval of the minutes of September 8th. Has everyone had other members had an opportunity to review them? All right, would someone like to move the minutes?
I will.
Thank you. Do we have a second?
Second.
All right. Jennifer?
Yes.
Andy?
Yes.
And I also vote yes. So those minutes have been approved. And now the same exercise for the policy minutes of September 10th. Jennifer moves them. Do we have a second? Andy seconds. Jennifer?
Yes.
I vote yes. I'm Andy.
Yes.
That also passes. All right, next up we have a discussion of the policy on immunizations. Now I see we don't have Ms. Laham with us right now, but at the last meeting, she had suggested that what we do is combine the existing policy with the statement that was not really COVID-19 specific from the MASC sort of default draft policy. Ms. Laham had also suggested that we be less specific in the language because it was somewhat obsolete in terms of the specific immunizations that we were asking of our students to provide. Casey, I'm wondering whether you could provide us with an update as to what the practice has been for this year in terms of what we are asking of families to provide in terms of evidence for immunizations or anything else that's health related.
Sure. So I don't think we have veered too far from anywhere actually from previous years in terms of asking families to provide updated immunization records. I don't believe that we are asking families to prove that they have gotten the flu shot. Although Tricia did send out communication to all families that students are expected to get flu shots before December 31st, 2020.
Okay, thank you. Jennifer?
I feel like, and I don't have the email that went out to families, but I do feel like it asked them to update those immunizations with the staff, including the flu vaccine. So we'd have to go and look at the specific language of the letter to see if it just, the tenor of it felt, well, I don't know, maybe it's just me and I'm a super rule follower. So I got my kids their flu shots and I sent the paperwork into the nurse. So I don't know, maybe I just assumed, but we could look and see if it did ask. It may not have said required, but it might have requested that families send us that information as part of their annual review of the immunizations.
Yeah, it was with the flu shot specifically in mind that I asked, I think last time, about whether we could go beyond, the list of things that was specified by the Department of Public Health. Like if it happened not to be required, but we think it should be, is it within our power to just require it?
Well, I don't yet have an answer from town council on that, but would anyone from the administration like to address that question about whether we can go beyond what the state requires in terms of immunizations?
I don't know.
Is that something that the committee would like to explore doing just more broadly, not necessarily for flu shots, but for anything in particular?
For me, it was just about the flu shot, especially in the current context. It could be a real problem for our operations if not enough people are getting it.
Maria, a question I have for you in connection to this, even though it's not really an immunization, but it would address sort of entry requirements for students. Have we ever been in the practice of requiring psychological wellness screens or anything like that?
No.
That's something that other districts are starting to do, given sort of there's a sharper focus, it seems, lately on social emotional wellness. I'm not sure that's something we would want necessarily in a policy as a requirement, but this is certainly something that's important. Has anyone seen shifts in that direction or no? Okay. All right, so I guess what we'll do for the policy immunization, I'll talk further with Tricia Laham about whether she wants to propose something specifically. If not, then I guess I can take that on, and then hopefully at our next meeting, we can discuss it line by line and maybe put it up for a vote for the full committee. Any other thoughts on immunizations? Jennifer?
I would just second your request to Tricia. It's her area of expertise. It would be really great if she could provide a draft that merges the existing document with the one that we had received from MASC. I just think that would be really useful. It's pretty short, if I'm not mistaken, so I'm very hopeful that she could help us with that.
Yes.
That's all.
Okay, so moving on now to discussion of the policy on harassment complaint procedures. So Maria was extremely helpful in forwarding me some model harassment procedures policies from other organizations. They are extremely dense and lengthy. One of them is literally over 100 pages in length, but it includes a lot of material that's more higher education specific that wouldn't necessarily apply to K-12, although some of it could if we wanted it to. Then there was another model policy that it is K-12 specific, and that one was over 70 pages, so still very dense. So there's a lot of material that we're gonna have to go through to get to that one. Then also I have received a lot of emails from members of the public who have a particular interest in various aspects of the harassment complaint procedures. On the one hand, we have some members of the public who would like everything to be spelled out in detail, which would tend to make for a longer policy, but we've also had other members of the public opine that they want it to be very simple so that a student would be able to access it and really understand what to do. My thinking is that perhaps we could go in both directions, where there's a section for students that's very simple for them to follow, and then sort of another section maybe for adults, administrators, and other people to whom the procedures would apply. I'm always reticent to make something more complex than it needs to be and to veer too specifically into the area of implementation of procedures, which is not what a policy necessarily is intended to address. But there's always a tension between that in terms of specificity. So I'm wondering what other members think about that. Jennifer?
Yeah, I find that some of our policies are really dense. And so I'm concerned that's concerning when I have to read it over myself. I mean, we read a number of policies and I have to read it 3 or 4 times to make sense of it. I think that it's too dense and it's too wordy. We want policies to be easily accessible to members of our school community, to our students, to our educators, to our administrators, to parents, to be able to understand them. So I think we need to, there are some things legally we probably need to put in there that need to be in. So advice on that would be helpful, but I lean more towards something that's more straightforward. That doesn't mean that something that's straightforward can't be highly specific. I think that we need to just be sort of clear amongst ourselves what it is that we need, that we require, or that the state or the federal government requires needs to be done by people who want to lodge a complaint or whatever the correct language is. And then what are the steps that those who are responsible for that, what are the hierarchy of steps? Like, okay, so a student or parent needs to file this paperwork, and then it goes to this person, and then what happens to that? And what are the steps that the people who are the administrators who are responsible for that work, what are the steps that they need to take? And I think all of that should be very transparent and accessible to all of the members of that community. So I guess I'm saying I lean more towards less is more, but there are going to be pages that have to be included for perhaps legal reasons. And I just think that we try to make it as accessible as possible. So 70 pages sounds I can't even, like no one has time to read a 70-page document. An appendix, maybe an attachment of like, here's sort of the legalese if you need, if you're interested and you want that. At the same time, there's a balance. We need to make sure that everything we're required to do is in this document and that it's clear, especially things like, I do think some things that are procedural, I'm more inclined to put them in a policy. Specifically, having read the prior drafts we've looked at, I'm very concerned about the length of time an investigation will take. Just having had experience sort of like with the bullying policy and the procedures and all of that, I don't think that it needs to take us 4 to 6 weeks, which is what, based on the document I've seen previously, it's looking like it would take up to 2 months to resolve a complaint. I just think that we need to, like, that's the discussion I'm looking forward to having, to sort of like, how does this play out? What are the steps that have to happen? Why do we think it would take so long to resolve that? Just because, these are people's lives both ways hanging. And so we really just want to resolve it, especially in like if someone's lodging a complaint because they feel that, for example, a student feels that they are being harassed, right, in their learning environment. To take 2 months to resolve that and remove that experience, it seems like, I can't imagine why it would take that long for us to get to a point we would resolve it. So those are some of the concerns I have, and just sort of my thoughts on like what the length of the document should be.
So my guess on your last question, and I'll then turn it over to Mary Ellen, Maria, Casey, and others, is that probably is a staffing issue, because I would think that any investigation requires a lot of resources. People are very busy. Everyone's spread too thin as it is. But would someone like to elaborate on why it's 4 to 6 weeks for the bullying policy, for example, and whether we think we could shorten the amount of time for harassment complaints, for resolving those? Anyone like to address that question?
I'm sorry, can I just clarify, David? I think I did not, it made sense in my head, and when you said it back to me, I'm glad you did. My understanding in reading the drafts of the harassment complaint procedures looks like it pans out to be about a minimum of 4 to 6 weeks. If I go by, I sort of mapped out how long it would take. It could be as long as like almost 2 months, I think, in some cases, depending on how we edit those timelines. And my experience with the bullying policy and procedures wasn't a great experience, but I think that part of that is the procedures, the protocols, the things that have to happen to train staff so that people know how to follow those. So I don't know that the bullying policy takes that long, but my concern is, having had experience having to utilize that policy, I'm concerned about how long it would take for these kinds, the procedures for this to happen. And I just think that 2 months is too long. And so I will be advocating that we sort of streamline as much as possible in what's reasonable, knowing, and I guess if there are budgetary implications to this policy, then that's something that we need to bring to finance so that we can make sure we have budgeted personnel for addressing this in the future budget.
So can someone from the
Jennifer does touch on an important point, I think, which is like, we can write a policy, but it doesn't implement itself, and nor do people just get trained automatically to do what they're expected to do under the new policy. So I don't know, can we write something into the policy that also specifies how people will be trained to carry out the policy?
I think Casey, I'm Justin Gomes. I'm from Stoneman Chandler Miller. Casey had asked that I invited me here because we were talking about Title IX a few days ago. So I apologize if I'm stepping on anybody else's time to comment. But I drafted a number of policies and been working on these issues recently. To answer just a few of the questions that you had regarding, one being timing of how long it would take to actually conduct one of these Title IX investigations or grievance processes, as they're referred to in the regulations. And then second, regarding training. They're two great points, and they're two things that actually address directly in the regulations. Just for overall context, one of the things that you said, David, at the outset, I think was spot on, that when looking for materials on these new Title IX regulations, most of the information out there is colleges and universities. And part of the reason, and at least in my opinion, is because they were drafted with colleges and universities in mind. But there is substantial sections for K through 12 schools, and we're just as much obligated to follow those regulations as a K through 12 school as a college and university is. They say reasonably prompt time frame. From what I'm seeing with most districts across the state, people are saying with the goal of within 60 days, with hopes of, with extensions for just cause. Just cause, in my experience, has been concurrent investigations by either DCF or law enforcement or some other extraordinary circumstance, such as an unavailability of a witness or investigation obstacle that's preventing it from taking longer. But other than that, in reading the regulations, what you'll see is that there's a number of due process requirements built into them, notice requirements for each party that just simply take a long time. So for example, before any party who's conducting an investigation interviews a particular person, that person needs to have sufficient notice and of not only when the interview is, but the topic of the interview and the parameters surrounding it. Now you can see when you're having an investigation that involves several different people, having to comply with all those notice requirements, things end up taking longer. So as a general rule, people are using 60 days or so with the hopes of completing it beforehand, and with the understanding that some sort of government inaction or obstacle would make it longer. Regarding training, that's something, you're right, that does typically end up being included in the policy. Usually the policies are saying, as the regulations do, that the Title IX coordinator is responsible for the implementation of this sexual harassment policy. As well, the Title IX coordinator is responsible for making sure that the procedures are adhered to, that the appropriate staff is trained, particularly anybody that's involved in one of these grievance processes are fully trained. So just to answer two of the questions, I'm sorry to interrupt, but I was hoping I could do that quickly, and happy to provide any other context to the extent necessary.
Thank you, much appreciated. Mary Ellen, do you know what the budget implications would be on being able to robustly staff a grievance process?
No, because this is the first I'm hearing about it. So that would need to get submitted as part of our FY22 budget process.
Okay. Maria, looks like you wanted to say something.
Yes, so I just wanted to reiterate a little bit of what Justin was saying about with respect to timelines, because I know we're talking specifically about Title IX, and it is very due process heavy, it's very prescriptive. So there are things that we need to ensure that all parties are, get the amount of notice, they have a proper amount of time to respond to things, all of that, which absolutely impacts the amount of time that the school has to fully go through the investigative process from beginning through end, through the determination. So there's that piece. And then just with respect to training, we've been looking at to recognizing that budget is an issue. We've been looking at and been following through on a train the trainer model, where we have been training particular staff members, myself included, in order to implement that training to the staff on the ground that will be fulfilling different roles, because there is very heavy training that is required, and specialized training as well, and it's very role specific. So all of those things come into play when we talk about training and the requirements that are needed. And as far as staffing, I think we're still trying to get our hands around what that is going to look like. Again, you mentioned folks are already spread very thin. So having to also go through an investigation and have that added to their role, we're still trying to understand what that will look like, since this is still a new, relatively new process for us.
Even though it's a new process, if we can use maybe last year as an example for complaints that were brought forth with the grievance process, approximately what kind of level of support was needed in order to carry that out? Just if that might give us some rough idea of what we can anticipate for this year and moving forward.
So already, if we're just looking at what it looked like last year, there were investigations where multiple, I'm going to use the high school because that is more regularly where a Title IX investigation would occur versus at the elementary schools. Typically several deans or associate deans would be involved with any given investigation. However, because now we're moving away from a single role in an investigation, prior, a dean might have been able to, do an investigation, issue the outcome, and then a consequence. That is no longer the case for us. There's the Title IX coordinator. There is the investigators in best practices have more than one. The decision maker. So there are several roles, and each person is going to be, multiple people will be involved in any given investigation. So that's why it's challenging to compare last year to this year.
Thank you. Justin, perhaps in your experience with this, do you know what other K-12 districts are doing around sort of staffing and assignments of who will be involved as investigators beyond the Title IX coordinator?
Sure. So I would say that it varies. For the most part, people's administrative teams are being trained on these regulations. Some are training specific people on the role of investigators because there are more, I would say, intensive and investigative training models out there. But in my opinion, it can be, you can train the entire group on all the functions. And the idea, at least that's contemplated by the regulations, is to avoid conflicts of interest and bias. Enough people are trained on the policy and what Title IX requires. That way, say, take for example, Johnny in Mr. J's class is accused of something or is bringing a complaint forward, and he's a designated investigator beforehand, that you have enough people that somebody can jump in and take over for Mr. J in that scenario. In some of the trainings that I've been involved with, not particularly in Massachusetts, but across the country, they talk about, they're having people from different buildings do investigations in buildings that are not even associated with them. So the rules are universally applicable. The regulations are what they are. So if you train enough of your administrative staff on that issue, hopefully by what the need is, given the circumstances of the situation, you can pop people in and out of those roles. And that's, Maria had alluded to there being three main roles. There being the Title IX coordinator, who's typically at least one person. So the regulations say that you need to have at least one Title IX coordinator per district. You have the investigator who conducts the investigation, writes a pretty substantial report afterwards that would be equivalent to a police report in a court proceeding. And then you have the decision maker, who has to be separate from the investigator. And then finally, an appellate decision maker, who we are typically suggesting be your superintendent, or another principal or somebody that's detached from the proceeding be the appellate decision maker. But really, those are just fancy names. It doesn't mean you have to hire new people for those roles. It just means that enough people need to be trained on what those roles are.
All right, thank you. Jennifer?
And I'm sorry if I was taking a lot of notes, and if I missed this, I apologize. We were talking about the number of staff we might need for these positions and the budgetary implications. Did we, and I feel like someone asked the question, and if I missed the answer, I apologize. Do we have an idea of about how many grievances or complaints we were processing, say in the last school year, so that we could have some idea of the amount of hours, right, that people would need to be dedicating to this, so that we could think about what those budgetary implications might be, so that we can budget for, you know, sufficient time so that we can be sure that we will be able to meet, you know, our own policies and procedures. Do we have any sort of data on that?
We do have that information. I'm not sure we have that for tonight. But one thing that's important, though, is that the Title IX investigations now will take a considerably more time than last year. So it may have been 10 last year, which may not have been too much time, but this year could look very different. So we can certainly come back to the subcommittee with this information. One thing that's worth mentioning is that the district is committing, I would think, a significant amount of funds to have administrators be trained in this train the trainer model. Maria can give some more specifics in terms of the training that's involved and the vendor, but that I think sets us up in a good place to ensure that those who are investigating are doing so compliant with the new regulations. And of course, hopefully if we get this policy passed sooner rather than later. But in terms of timing, you know, the amount of time it costs, I think we'll have to get back to you on that until we can actually have a really good idea of what it involves. I think obviously the first few will take a lot longer.
So do you think that, just to follow up, you said that you thought it might take more time, Casey, this year versus last year? And is that just because it's a new set of procedures and we're just sort of figuring out, making sure that we do all of the appropriate pieces? Is that correct, my understanding?
Yeah, so Justin can speak more to this than I can in terms of just what the new requirements are. There's also reading of, is it like a preponderance of evidence? I mean, there's just new levels that we have to hit, I think, in terms of investigations.
That's completely right, Casey. And I don't know, I apologize, I don't know what Brookline was doing beforehand, but the regulations also eliminated what's considered a single investigator decision maker model. So because you're separating the role of each of those people out, it's just simply going to take more time for each person to analyze what the other has done. And it's built that way. People aren't intertwined or becoming too attached to what their function is and it ultimately affecting the decision. There are a lot of things that have changed that are going to draw out the process, as we talked about earlier. The simple due process requirements in terms of notice, but also, you know, for example, after the investigative report, which has to be written and followed in a certain way, the students have up to 10 days to respond to that. And they have the opportunity to respond to that in writing. After a final decision is made, that also is prescribed how that decision is supposed to be issued and what's supposed to be considered in that decision. And then folks have an opportunity to respond to that as well. Those are two major steps that are done by different people. Then finally, this is one of the things that K through 12 schools have particularly trying to wrap their heads around, is the adversarial part of this. In colleges and universities, they're actually requiring live hearings, mini proceedings where advocates are responsible for advocating the position of the complainant and respondent throughout a Title IX investigation. Though you're not required to do that in K through 12 schools, you do have the option of doing it. And if you do that, you have to follow also additional due process requirements, which just naturally take longer. But
that's a good point. Can I just interrupt you real quick, Justin, for that about the live hearings? I forgot about that. I think, doesn't the school committee have to vote on whether or not they will allow live hearings as part of the investigation?
It would potentially be something in your policy. The regulations don't say whether or not school committee has to vote on that. However, it is an option. What I'm seeing most districts do, reserving the right for a live hearing. But to be frank, in most circumstances, they're not going to be appropriate for a K through 12 school. But in lieu of a live hearing, what you are required to do, no matter what, is they call it a exchange of questions. Anybody who's been involved in a lawsuit might be familiar with interrogatories. It's a simplified version of interrogatories in which each party is able to submit questions of any witness or person involved to the decision maker, the principal or vice principal, whoever it is here. They evaluate that question and then ask it of the other person. And then there's follow-up that can be allowed for that. So as you can see, all these due process protections that aren't discretionary, they're mandated by law. They really draw the procedure out.
Andy?
Yeah, so if I remember the last time we discussed this, so the question of how many cases were coming up per year, that was in connection with us wondering whether we should be trying to write like a unified policy that covers all forms of discrimination and harassment, or whether we should have a separate Title IX and continue treating others somehow differently. So I think it was on the one hand, it seems nice to have a uniform way of dealing with all types of these. And currently, I think we had separate policies for bullying, for discrimination as it applies to staff, and for discrimination as it applies to students. It'd be nice to clear up some of that. On the other hand, right, if these Title IX procedures are extremely onerous, we don't want to have that chilling effect sort of spread to sort of all the other areas as well. So what would you recommend here? Should we try to unify?
Well, I won't. I'll just tell you what some of the factors are to consider. One of the factors is the general, and if they are challenged and parts of them are stuck down.
Sorry, Justin, I think we're losing your audio.
All of your harassment regulation.
I think we're losing your audio.
Oh, I apologize. Can you hear me now?
That's
sort of.
Yeah, maybe if you turned off your video or something, we might be able to.
I apologize, Eric. Can you hear me now?
Yeah. So
okay.
I think your whole response was lost pretty much. So if you could just start at the beginning.
Okay. Yeah. Sure. So I'll just tell you some factors to consider. I'll say that most folks are doing two separate policies, two separate procedures, so to say. So maybe perhaps you have a harassment policy that includes everything within it, your general harassment guidelines, and then sexual harassment, because sexual harassment is a subset of general harassment. But when it comes to your procedures, having harassment procedures, then Title IX procedures, and the reason for that being, if anything happens to these regulations at the federal level, whether it be from a legal challenge to them by the states, which is going on right now, or even a change in administration, potentially the regulations could be thrown out as well. So you want to be able to adjust accordingly. Then finally, those are just the timeline considerations to have, practical timeline considerations to have, like what could happen over the next few months. Finally, I think you're right to consider whether or not they're appropriate for all forms of harassment, and ultimately it's a decision to the school committee of what sort of conduct or what kind of prescription they want to have to prohibited conduct. That being said, procedures typically are implemented by the superintendents and the administration. Some school committees are including procedural language in their policies, which are prohibitions and then certain things that the procedures have to do, but not necessarily a step-by-step of what is going to happen when a Title IX investigation occurs.
Jennifer?
Sorry, I'm sort of circling back to some of the notes. So I just wanted to say, yes, I would love to see the data on the past grievances and how they're split out. I know we talked about it last time. I was thinking we would get it this time, but if we could definitely get that at our next policy meeting, that would be really helpful. And I don't know, David, if it's helpful for some of the members of the public to just sort of clarify, we didn't really state this at the beginning, that there's certain limitations about what we'll be able to do with the policy based on the mandates that, that Justin was just talking about that are coming from above us, just so people know that we are in fact limited in some ways about things we will be able to take in or put in or take out rather from our policy. And I'm just gonna go back again to the 60 days. Is very concerning to me. And I'm just wondering, in what ways are we able to think about our policy in being able to protect people during this process from retaliation? And so I just don't know where that's appropriate or how that works, but 60 days just seems like such a long time to file a complaint and then have it, some sort of intervention or response taken. And I know, I don't know. So I'm just wondering in what ways, if just to imagine you're a student and you file a complaint or a grievance, and then it takes 60 days. A lot can happen in 60 days. And so I'm just trying to think about how we can support our students and in this process and what can be done on a policy level about this, because it is a real thing.
Yeah, I think what you're saying makes sense, Jennifer, but I do want to parse out though, like bullying investigations are done within 7 days. So there's that. I think when Justin said the 60 days, that was Title IX. I don't know. Yeah. So, I mean, I do think that that's important to separate that.
I hear you. Yeah, but I wasn't even talking about the bullying. I'm talking about, like, say a student needs to make a sexual harassment grievance, file a grievance about this. A lot can happen in 60 days to that student, retaliation or staff, whatever it is, whatever member of our community needs to file that grievance. I'm saying I wasn't talking about bullying at all. I was completely thinking, about harassment, and just that 60 days is a long time and a lot can happen. There's retaliation that comes with filing a grievance, and then there's so many notifications that have to happen and interviews. And so there's a lot you have to do, put yourself out there for in order to go through these, interviews and exchange of questions. And like, I started having a panic attack just thinking about live hearings for our young people. So I guess I'm thinking, just to frame that in the harassment policy, specifically to these, if it takes 60 days, and I appreciate clarifying that's not what's happening with bullying, the bullying policy or procedures, but in this case, how do we support the people who are, and I want to think about it both ways, the people who are filing a grievance, but also the people who are also dealing with the repercussions of a grievance, right? Because there's many parties to this. And so how do we support our students during this, what are the policy pieces, or maybe it's procedural, to support people during this possible 60-day timeline, from being retaliated? Are there things that are in the regulations that are protections already? Maybe someone could highlight those. Thank you, Casey. I didn't mean to interrupt. I'm sorry I interrupted you, Casey.
So to your point, Jennifer, absolutely. Supportive measures is a requirement of Title IX. So as soon as we receive notice, we are, the Title IX coordinator or deputy is in contact with the complainant to talk about supportive measures, go through the entire process, ensure they understand what their rights are, what the options are for filing a formal grievance. And then if that's moved forward, all parties are informed of, all the rights and the processes, and supportive measures are required for both the respondent and the complainant. So that is part of the Title IX process.
Now, beyond the requirements, are there additional supports you're providing? A member of the public who's with us right now, Ms. Liz Stillman, has asked what support we can provide for students who are vulnerable members of the community, perhaps students with disabilities, around this process so that they don't necessarily feel like they're falling through the cracks. Is there something we're doing beyond the minimum of explaining to them their rights?
So supportive measures involves looking at the particular situation that is occurring, and then what can we do to mitigate what is occurring at that particular moment. It's an individual situation. So we would just look at what is occurring with the potential cases, the complaint that's going to be filed, and we need to mitigate what's going on right away. So it could be providing, counseling services, meeting with the counselor in school, doing outside referrals, looking at, possibly scheduling or some type of safety within the building. So it's really looked at on an individual basis for each situation.
All right, thank you. And then sort of a similar question in the reverse. What do we do to protect the accused during that same time frame?
So again, this is a very due process policy that has been implemented here. All the protections for the complainant are there for the respondent as well. We would meet with the respondent. We would also put in supportive measures as well. Supportive measures cannot be punitive. They have to be fair to both parties. So it really is being objective and fair to both parties during the entire process.
All right. So for committee members, what would you suggest in terms of the best path forward for actually bringing forward a policy that we could vote for in the near future? Or members of the administration of central office, if you have suggestions as well. Jennifer?
So Justin, you said you were working on policies for other districts. Is that something you do? Like as in you prepare possible drafts of policies that follow federal and state regulations that are easy to read? Is this like, can we outsource like a draft?
That's why I brought him here, because he does that and he provides trainings to schools. Not specifically Title IX, like I could be wrong, Justin, maybe what we're doing, but I know you've been training other school districts in Title IX.
And I guess the other part of that, sorry, is Mary Ellen, is there a budget for this? No.
This is
well,
this is pennies on the dollar. I mean, when I started in 2015, Lisa Jackson was charged with doing a policy manual update and hiring MASC to do that. And so, I think, do we technically have money? No, but the dollars are short dollars in the scheme of things. And certainly I think it's something that with important policies like this one specifically, it's really important to get it right and do it well. So, it's easier it's short money to fund this than it is to fully staff and go to a staffing model to implement a policy that's not going to be effective, potentially, I should say.
We also have, the Office of Student Services has a pretty sizable contract with the firm that Justin works for. So, and that's, year long. So there are funds already that have been allocated as part of that contract. for, hourly work. So as long as we get an estimate from Justin, it could already be, the money might already be there.
So I would be in favor of the outsourcing that's being proposed. Your thoughts on this?
Do we just need to make sure to identify the existing policies that would be superseded by this one? Because I'm not, right, it's not a one-to-one thing, right? I think there are several that might be partially or completely superseded by this. So we need to figure out what those are first. As for the outsourcing, it also sounds great to me, but it's
So
what we need to do.
So I have no opinion on the outsourcing, but I'll just tell you, just if I could, I'll opine quickly on what usually the task I'm giving people. It's, you need a new policy that redefines sexual harassment as prescribed by the regulations. You then need to have new procedures, which don't necessarily have to be included in your sexual harassment or harassment policy. Those are typically adopted by the administration. But then once you have those two documents typically require you to revamp your existing overall harassment policy. And perhaps if you already have a sexual harassment policy, or you already have some sort of anti-discrimination policy, where all these things, we're in K through 12 education, there's more regulation, state law, and hurdles that we have to go through. So there's a lot of things that are intertwined here. So once you do a revamp of those to make them sort of merge, the next thing is really training the appropriate staff and publishing those two documents. Those are the three things that are really required. Adopting a new policy, making sure you have and having procedures that coincide with that, training the appropriate staff, and then publishing both of them. That way people know what they in fact are. And the regulations also prescribe where those things need to be published. For example, in your handbook, on your website, and to particular personnel.
When you say publishing both documents, what are the two again?
Training requirements and our policy. So all the training material that we utilize needs to be
that is published. Okay, so it's the policy itself and the training materials are the two things we need to publish. Okay.
Another related question we have from Ms. Stillman, member of the public, is whether we can go beyond what Title IX requires so long as the requirements are met.
I think I need more info on what that means, go beyond Title IX.
Well, for example, if Title IX obviously guarantees certain protections, so can we exceed those guarantees and guarantee even more?
It's hard to answer that right now, not knowing on a case by case. I just worry that if we say yes, and a case pops up where someone actually ends up not being protected in a way that they would need. I don't know. I think it's hard to give a blanket statement, but Justin might be able to answer that. I don't know if you heard the question.
So I did, and I'll say, general rule, remember that all of your state law requirements are still imposed. So though in some circumstances, the federal regulations may not cover something, as educators, you're required to do other things that are typically covered by state law, or the chance for liability under state law is greater, even though some may argue that it's not as much as it was before under these new regulations.
All right, thank you. So moving forward then, it sounds like it's the will of the subcommittee to outsource the drafting of this policy. I do think Andy's point, of course, is very important, that we make sure we understand its impact on other policies and what this one would be superseding. I think, though, that portion of it is probably something we would be able to do. So if we could have a draft provided to us, and then we look it over and we make sure that it doesn't have any unintended consequences on other policies. That piece of it I would be comfortable doing myself, but if someone else could draft it, Justin, maybe you or your firm, and if we can get approval to do that, I think that would make the most sense, because this is very important and we want the experts to make sure that we're going in the right direction. All right, any other thoughts on the policy on harassment complaint procedures?
No, Justin, I can follow up with you so that we're prepared for the next subcommittee, policy subcommittee meeting to have that draft. Does that sound right to you, David?
Yes, that would be great.
For the November meeting? Okay.
Okay.
And can I just clarify? So we're doing a redraft of the harassment policy to include the new information, the new things prescribed by law.
Yes, that would be very helpful. Okay, so next up, and I see that we have Megan here, is a discussion of the student residency policy. This has become an issue in a virtual setting that we currently have now for some of our students with the Remote Learning Academy, and that we have with other students who are in hybrid, because some students are now residing in vacation homes, or they are in other countries, or they're in other states, and they feel that given that if they are able to log in and access their studies that way, that it shouldn't be necessary for them to be physically residing in Brookline. So I'm wondering what the, first perhaps we can hear from Megan about more details around these issues.
Yeah, thanks for having me. So there's a few issues going on. The residency policy, as outlined in our current policy, is pretty standard practice across the state. It's where you lay your head is where you are residing. So the place where you're sleeping in the evenings on instruction days, essentially the gist of what it means, and it's how it's been interpreted by case law, et cetera. That's where your residency is. And residency is the thing that gives your child eligibility to participate in a given school district's learning community. So what we're dealing with, as you said, David, is we have families who are not residing in Brookline, either due to some exigent circumstances. There are some students who have some situations and some trauma-related things. We take all extremes, that have caused them to need to leave Brookline. We have students who are residing in vacation homes on the Cape, in Maine, et cetera, because they feel it's a safer place to be to ride out this current situation. We also have families who have left the country and are residing in other time zones altogether. And so that's creating quite a challenge. So, my dictate as the coordinator of enrollment is to, uphold residency policy. And so as it's written currently, these families do not qualify for residency, and they don't qualify to be, continue to access education through PSB. We do think there might be some adjustments families will make once hybrid becomes in place in a couple of weeks. Some of these families will probably, be able to make adjustments and come home so that their kids can be in person. But that doesn't change matters for the students who are currently Remote Learning Academy students either. So that creates quite a challenge. It's very difficult to ascertain where these families are and whether they should be students.
Now, could you explain to the subcommittee sort of the scope of the issue, how many students this seems to be an issue for currently?
I mean, I know of it more than a dozen, but that's the ones that I know for sure. Like, it's already been identified. That doesn't mean that there aren't more. We're also seeing that our educators are, somewhat reticent to notify us that this is the situation as well. Because they're their families, they want to care for their students and such, so they don't want to share that information with us as readily as I would hope they would either. So I know there are more. They crop up one every other day or so at this point.
And could someone perhaps explain how this impacts our resources to have students who are not physically residing in the town but are enrolled in our schools?
I mean, so in terms of one major issue is when students are residing in time zones that are not situational for learning in Brookline. You know, they're 12 hours ahead, and we have students who are waking up at, you know, midnight to study with their teachers. That's not good for the teachers. It's not good for the students. And then, of course, there's the pupil cost that we're paying for these students. We don't have any proof that they are remaining taxpayers in any way necessarily. But it's also important to remember that, you know, we don't want to benefit only owners, for instance, who might have the means to have a second home, or other folks with other circumstances. We would want the policy to be applied fairly to all of our residents. So we have folks who are working very hard to retain their residency, understanding that that is the policy, and others who are choosing to look at it differently. So it's my hope that we can get to an understanding of how best to apply this and practice it equitably for all of our families.
If I can add
not have
to
any consequences moving forward also.
Yeah, David, to your question too, in terms of how this impacts our resources, we are getting requests, our principals, and to some extent directly to our teachers, requests to make accommodations for students who can't log in live when they are outside of Brookline. And teachers and principals feel compelled to help. But as you mentioned earlier, people are stretched really thin. And so asking teachers to accommodate a student who is, you know, on the West Coast is tough to, you know, to have them teach during a different time or have them prepare coursework, you know, for you know, a week in advance kind of thing. It's hard. And so that's where we're looking to you. I mean, this is why Megan reached out to see if the subcommittee could provide us with some more direction in terms of applying the policy currently.
So I'd also like to add sort of the traditional equivalent to the situation, which is the family that rents an apartment in Brookline and drives from Waltham or drives from Boston, and they're actually living in Boston, or they're actually living in Waltham. Those are our normal sort of old time cases, pre-COVID cases, where we would be tracking students down that had rented, you know, rented housing, kept an address, but really never lived there. The place was empty. They didn't reside there, weren't paying taxes there. They were actually owners or living in another community and driving in. So that's sort of the equivalent that's happening in terms of, you know, with a remote, you know, you're just dialing in versus driving in to Brookline for education. So there are resources, and I think some of our concerns of our teachers around taping of classes and videotaping and things like that, you know, maybe they're not saying that this is part of it, but I think to Casey's point and Megan's point about the supports that students in different time zones, different locations, they're not here in Brookline. And so those are going to put stress on our teaching force. And normally we wouldn't have those students in our schools if they were driving in. This time the highway is the internet.
And the other consequence, of course, is these are current students, but that also would impact new enrollment policy. You know, if we let one family do it, what's to say that a newly enrolling family in Waltham would not want to, of course, access PSB instead. So that's also corollary.
Well, we already do grant exceptions on a person-to-person basis, don't we?
They're pretty restrictive. You have to be a senior graduating or the last few months of school. We're at the beginning of school, so it's not typically done.
Yeah, the other
time it's done is if the house,
like a natural disaster or things like that.
Yeah, where you have a major house reconstruction, you know, domicile situation reconstruction, None of these people are deemed homeless, so that doesn't apply. And so yeah, but not to the fluidity and ease at which it is, I think that we're seeing.
Length of time is also a consideration. So exceptional circumstances does also say that they're temporary. Another place in the policy speaks to 3 months or less. So we're going well beyond 3 months in many of these circumstances.
Jennifer?
I'm just very concerned to hear that, you know, people are like being on the West Coast like for long extended periods of time and actually requesting that people make adjustments to like do a whole nother workload because you're somewhere like, I think people need to do and go where they need to go and they need to do what they need to do. But I just think that's an incredible ask of our educators to redo a whole system or start recording things or do any other additional planning because of choices families are making. So like that's just, I got stuck in the conversation right there. So I'm trying to think of, like I do know, I'm sure we have a number of community members who maybe have second houses down on the Cape or other places. Like I can imagine that that's the case, but that's just at least the same time zone. And if you're remote, you're remote. I mean, so that's easier. I mean, that just, I get that's a thing. I think when people come in, I don't know, this is a really tricky conversation. Like when is remote not okay? And how do we know and confirm that these people are actually members of our community and not people who have actually left the community and are living in another place and want to stay here? And so I think, one possibility is requesting a confirmation of like housing status for people who we know are not physically, their domicile, like current domicile is not in Brookline. I don't know, that's a really tricky conversation. I mean, I think there's some like gray area with like in the state, but I mean, even then, like, I think it'll make a big difference when we're back in hybrid and to see how many of those people say, oh no, we want to go to like RLA, or maybe they're already in RLA. I mean, I don't know. Those are my initial thoughts. I don't have an answer. I don't know. I think we need to talk about this. I suspect that the whole committee will have opinions about this.
So Mary Ellen, in your Waltham example, I don't think people are usually getting vacation homes in Waltham, but if there's a vacation home in say Cape Cod, and how do we really know where the student is sleeping? Now, I would think that they're not doing that commute on a daily basis, but there are probably times where maybe they do, where they drive up on a Monday morning with their family, for instance, and they've got Friday night, Saturday night, maybe even Sunday night in their vacation home. I doubt that we would be telling those students they can't be in the Brookline schools. So is there sort of a defined minimum?
Yeah, so part of it is you sort of go to the, it's the majority of nights where a child lays their head. So your example of sort of the weekend, warrior kind of thing is that they're here on Monday, they leave on Friday. So the majority of the 7 days they're here, their head is in Brookline. And we deal with that with divorce and child custody cases all the time about sort of what those splits are. And which school districts do kids get to attend and do they want to attend, which parent and how many days. And so that majority of days is somewhat of a pretty much a standard for a lot of different situations. And the long-term concern about this remote is that we could be remote could be part of our educational infrastructure into the future. And so what would prevent us from having to educate kids from anywhere in the country? But, we become basically a choice school district because you don't really have to prove where you live because you can attend remote. So there's a slippery slope here in terms of the long-term, short-term and long-term. But the guidance has always been about where does the child have their head the majority of the nights of the week. And so that's why 7 is a great number, because it's either 4 or greater than 4 or less than 3 or less. So I don't know if that helps.
But even then, it's more of an aggregate amount, because in the example you gave with a divorced family, it might be the mother has the child for 3 weeks in Brookline, and then 1 week the child's with his dad in Newton.
Yeah. Yeah, you could have, believe me, they're 180 days. And sometimes I have actually seen one case where it's split down the middle in 90, and you know, you flip a coin at that point. And both districts at that point are gonna flip a coin and say what's best for the kid. But that's not what we're talking about here. We're talking about people intentionally not living in Brookline, whether they're renting an apartment and going to some northern state, Maine, Vermont, New Hampshire, and renting an apartment and not really being here. Whether they're in the remote learning academy or not. So all of those kids, all of those extra kids, where it hits us in our budget is all those extra teachers, all the extra paras we need to hire to support those students. And on an aggregate basis, that can be a lot of money. I mean, we've already lost, I mean, I don't know, what are we down total from most of our international students having to leave the country? That's a large population. So now we probably have another, I mean, is it conservative to say maybe there are another 75 to 100 students or more in the district that actually are not living in the district? Well, divide by 21, and that's how many teachers and paras you don't have to necessarily resource.
As a practical matter, how do you determine where someone is laying their head from one night to the next?
With great difficulty.
Yeah, I mean, we'd have to hound people pretty hard to gather all this information.
Yeah, I mean, there are some things that are pretty easy. You know, the first piece is having clear expectations from us to families. That's the first challenge that we're facing right now. In the spring, when all of this began and we went suddenly remote, these rules were relaxed. It was allowed for families to do what you need to do to keep safe, stay safe, make your plans, right? So I think there has been some confusion sown in the community, and so that's fair. But we're now, you know, 6 months later, and families are continuing. They've made these changes, but haven't adjusted their enrollment process. So that's the first piece, right? Is being clear what the expectation is. So if it's okay for them to be remote and not in Brookline, I'm not going to spin my wheels trying to hunt everybody down. If the expectation is no matter what your learning model is that you're here, then we have to start doing some steps to figure that out. The first is we ask families to identify that they understand the rules, right? They have to sign an affidavit, which is required by policy, that they sign an affidavit yearly, that they understand the policy. And then we also ask them to provide some evidence that they are maintaining that Brookline home. And then we also ask our school community to participate and help us with this. You know, our teachers know, you know, hey, it's a bright sunshiny day here in Boston area and this kid is sitting in the dark and it's not because the windows are closed. You know, they're gonna see some things that are gonna be evidence. In the same way we would say, you know, this kid is always late. In typical circumstances, this kid is always late to school. What's the issue behind the tardy? And we would dig into that. You know, that might be a social emotional issue, right? Or it might be that they're traveling from, you know, the Cape, and that's why they're late. And so then we do some further investigation. But that's the general idea of how we determine that. And it's challenging, but there's some cases where it's very clear. Sometimes parents just tell us.
And kids tell us.
And the kids tell us.
You know, it's just a normal course of conversation.
For remote learning, are we tracking IP addresses and that's how we're finding out where some of these people are, or it's been that they disclose themselves?
No, but we do actually have some security issues with that we are actually tracking, which I can talk to you offline about with regards to our network. So some of that is going to start popping up.
So I would just hope that I'm in agreement with, I think, the sentiment of what I'm hearing, that we definitely want to safeguard our resources and we don't want to be becoming a de facto choice school. We don't want to be overburdening our educators with even more work by accommodating students in other time zones. However, I would want to make sure that we continue to provide an opportunity for individual families to seek exemptions to the policy where the circumstances might be appropriate. I discussed with Jim Marini one potential scenario where right now with the pandemic, there are people who are there are certain countries that just will not allow people to travel back to the US. And maybe someone lives in Brookline, really wants to be in Brookline, but because they cannot fly back, they are still in a country in South America that might even be in our same time zone, because time zones, of course, are longitudinal. So it's not really an issue from a teacher workload perspective, and it's not really the fault of the student that they're not able to travel back. And let's say that maybe in January they could come back and they'll come back. So those types of situations, I hope we would have some sensitivity around that. But more broadly, I'm not sure that I'm hearing anything that requires a policy change unless someone has a suggestion otherwise.
Well, I think your scenario is that technically that international IP address should be blocked by our learning management systems, and they shouldn't be allowed in to begin with. So that in and of itself is, leaves that scenario to not even be considered.
Jennifer?
I guess the really gray area for me here is, so I don't think it's reasonable expectation for people to decide to utilize a residence they may own outside of Brookline during the pandemic and expect that we can alter our school day or times or our typical procedures. I think the gray area for me is that I'm sure there are a number of people in town who own or rent and therefore through whatever mechanism are paying their taxes and are residents of Brookline, but also own a second property somewhere drivable. And it may be the Cape, it may be Western Mass, it may be Vermont or New Hampshire. And they're paying their taxes to Brookline and they are temporarily relocating somewhere else. And they're figuring, hey, my kid's in RLA or we're remote, it doesn't matter. They're really Brookline residents sort of temporarily like quarantining elsewhere. I think that's going to be really hard to discern if those folks are at their Brookline residence or at their other residence. And I think people will feel like, but I'm paying my Brookline taxes, I'm a Brookline student. I may not be physically there right now, but I'm still a Brookline student, or my kids are still Brookline students. And I think that's pretty fair. Like, I wish I had a second home, I don't. It would be nice, but I think that's the really gray spot. That's where people will get really angry because they're gonna be like, but I have a right to go to school there. And so I think we need to be really cognizant of that. That's a very different feeling than people who are making a choice to be physically located somewhere else. I mean, our numbers are pretty good in Brookline. I mean, I think maybe even we'd have a different conversation if we were red. I don't know, but we're not. And those are choices people make, but I just think if you're on a different time zone or you're overseas and it's because it's different if you can't get back in. It's another thing to me if you're there on your choice. I think the message I think to our teams of educators and administrators, to me, I can't imagine that we would tape and make all these accommodations. That's huge. That's a huge time commitment for anyone to do and say, well, I'm going to try to tape these, or can you make adjustments because my kid can't be there? We're going to miss half a day of school, or like that. I don't know. That's like a bridge too far for me. But I do think we need to think about those people who do own and pay taxes here and have a right to go here and are regular students that may just be temporarily somewhere else during this remote period. I don't know. Sorry, David, that doesn't help very much, but I just can't.
I would like to just remind the case law stands that, just because you've bought a condo, and even if you're renovating it and you haven't moved in, you don't qualify for residency. That's just how it works. So even in your example, Jennifer, it's hard, right? Because that family feels like a Brookline family, but they are choosing You know, it's their own choice. They have two homes and they're choosing to reside in another municipality, whether it's in Massachusetts or another state nearby where they can get to here. So that's where it gets complicated too, is like, you know, there's the emotional attachment to the community and their education and their, you know, their educated community and their peers and all of that. However, that family has made a choice, right? And if they are have the means to make that choice, that's wonderful for them, but they also need to understand. And we have to understand where is the line.
Right, and I just want to throw out the equity of this, like that again, they have the means to do that. And for families that don't, that is completely unfair that they would be, you know, excluded from you know, the Brookline school system, but feeling the same way that they are, you know, part of the Brookline schools and part of the Brookline community, but because they don't have the means, they would not have that same opportunity.
I would also add, Jennifer, that given Mary Ellen's explanation about it's more than half. So in theory, a family could be in their vacation home for 2 months straight. And as long as they're spending a majority of their time in Brookline, they'd still be fine.
So then I think it's, you know, a lot of this is like making sure that the explanation, making sure that people understand. I think maybe it was Megan or maybe, I don't remember who now, said about expectations. Like, what are the expectations? Mm-hmm. So that community members can understand, like, we're trying to get our kids back into schools. We're trying to go with hybrid. We understand that people need the remote learning model for a number of reasons. But the expectation is that the core educational experience is here in Brookline, and, you know, people may have second homes, and that's secondary. And so maybe an explanation about the percentages of time, or I don't know. I mean, something that makes it clear to folks that, you know, we're hoping, you know, my goal is for us to, you know, get kids back into buildings and get back to a regular schedule as soon as. I'll be the first one to say I want it to be safe first, but, you know, I don't know.
Hopefully a lot of this will become moot once hybrid starts more in full force for grades 1 through 12. And I'm also hoping, although this is a different discussion, that plus becomes very real, and that might also encourage some people to come back. Andy, I see that you are trying to talk.
Oh, no, I was taking a sip of water, but I did have a question, which is who currently is the decision maker in a disputed case like this?
So ultimately, I bring the case, and then if it makes it to a hearing, Mary Ellen is our hearing officer.
Mm-hmm. So is it, Mary Ellen, is it some kind of, what are you looking for from the policy subcommittee or from the school committee here, given that we're not going to rewrite the policy?
There we go. I think it's really that the policy stands, and that, you know, the expectations, I liked Megan's sort of intro to it in terms of the expectation hasn't changed. We still expect you to be residing in Brookline. And there are enough variables that we consider in a lot of different cases to really take into consideration what's in the best interest of the student. But the one thing that is always constant is that you are residing in Brookline the majority of the time. And we've actually removed, in my 5 years here, we've removed a number of people who literally have rented apartments but live in Boston, or live in Waltham, or live in different places. They are not they don't live here. They need to be going to school in those communities where their community is. I mean, their social network is in those communities, or whether it's religious community culture is there. And so that's part of the consideration. And it's, so that's kind of that's what I look for, is that the policy still stands, and that just because we're remote, that doesn't mean that if they have resources that offer them other options, that we still expect you to be residing in Brookline. I think for me, with all of the talk around the school committee and parents wanting kids back in schools, we go hybrid, I bet we're going to find a ton more students because people are not going to be able to get back. They're going to think they can be remote all the time and not be in the cohort that comes into school. I think, I mean, the pressures on teachers is going to become huge. I think it's going to be bigger than we may realize. I'm not sure. If we're sitting at 50 kids so far, that's a lot. Even out of our numbers, that's a lot. If we were at 1 or 2, I'd be like, yeah, there's 1 or 2. But word gets out and accommodations get made. We don't have the, it becomes a resource allocation question. I don't know if that helps you or not, Andy.
Yeah, and for myself, I mean, I would like to sort of have the blessing, if you will, of the committee to begin that query of parents, to lay out that expectation and ask them to sign the affidavit. And then if they want to come to us with, questions, then that's fine. But I've been waiting to do this simply because it's been a little unclear as to where we're going to stand with this very sort of moving line issue. So for me, I would like to move forward with that first step, particularly before hybrid begins. Get that out to the community so that they understand exactly what the expectation is.
Speaking for myself, I'm supportive of what you're just outlining about being able to deliver expectations to the community about students needing to spend a majority of their time in Brookline, that you have to be a Brookline resident in order to enroll in the Brookline schools in any capacity. Andy, Jennifer, what are your thoughts?
The same in my case.
Jennifer?
Yeah, just going with sort of restating the expectations.
Yes.
Yeah, I mean, I'd be interested to see once we go hybrid, if we could sort of keep an eye on some of this information and this data to see if those people then want to go RLA at the hybrid change now that the deadline's coming up. And I just, I think that the wording of this restating of the expectations is going to be really important to community members as well. So they understand like why, why the expectations are what they are and the impacts that it has. So they have some context for like, why is this coming now? That might be helpful as well.
Was there ever an explicit relaxing of this in the spring, or is it simply that things stopped being enforced and then people got used to the new normal?
When people came and said, I need to go, we need to go, be with family who, we need to go. We can't get a flight out. We got a flight, we got to go. And it was like, that's fine. Do what you got to do. And our instruction was very different in the spring, to be fair. The structure was very different for students and for teachers in the spring than it is now, after all of the work that everybody here has done. So, it was more on a case by case, but as we all know, people talk. So I'm sure people are aware that it was relaxed in some ways.
All right, would anyone else like to speak on this policy? Are we ready to move on to the next item? All right, so moving on, our next topic is town meeting warrant articles and whether we want to recommend to the full school committee to convene public hearings on school committee recommendations for town meeting votes. So I don't know if everyone had an opportunity to review the town warrant and the various warrant articles that are going to be presented at the November town meeting to see which ones we think are relevant to the schools. I went through them and put together sort of a preliminary list of warrant articles that I think are relevant to the schools. Some of them are quite obviously relevant because they flat out mention schools, or they touch upon something that would impact the finances of the schools. A couple of them are a little more borderline because it might have an impact on some of our students. And in the past, school committee has sometimes wanted to take a position on those issues, even though they were a little bit more tangential. And we have a different composition of the committee now, so I don't know if we'll want to continue in that tradition. So I guess we could just go warrant article by warrant article based on the list I put together, or go ahead, Andy.
I was just waving goodbye to Maria, who was, I think, was stepping off.
All right, so starting with the special town meeting within the town meeting, there are just 3 articles for that one, but 2 of them very clearly pertain to the schools. So one of them is additional funds for the high school project. Is it the will of this committee that we weigh in on that, whether we want town meeting to provide additional funds to complete construction of the high school? Andy?
If we don't weigh in, will they assume that, I mean, is any assumption made if we just stay quiet on this? I mean, it seems clear what.
I would think that town meeting would want to know that the school committee cares about something that impacts the schools very directly. I have had, as a member of town meeting myself, I have had other town meeting members approach me and say, why isn't school committee taking an opinion on this? Do the schools don't really care? If you guys don't need it, then we're not going to provide it. So that usually comes up in the context of something that impacts funding or something that impacts a capital project. So I would strongly recommend that we do take a position at minimum on warrant articles that explicitly mention the schools. Jennifer, are you on board with that?
Yeah, we typically have made a habit, a practice of making comment on anything particularly that, you know, relates to the schools. That's been how we've done it. I think it makes sense. If we don't have anything to say about it, I don't know why anybody else would.
Right. So I would like to move that we take a position on special town meeting warrant article 2, which is essentially to provide additional funds for the high school project. Jennifer?
Is this a vote?
Yes.
Yes, I vote yes.
Andy?
Yes.
And I also vote yes. All right, so the next warrant article that I recommend that we take a position on is special town meeting warrant article 3, which is acquisition of the Newbury College West parcel. So just as a reminder, but more for you, Andy, the school committee voted unanimously last year toward opining on the acquisition of the Newbury parcel for either school use or general municipal use. We didn't specifically say that it should be for school use, but we put both of those, school or municipal. And I think the reason why it's important that we essentially, again, form an opinion on this warrant article is there is that potential that we're going to want to be able to utilize the Newbury parcel for some kind of school use, whether that's for students or administration at some point. So my recommendation would be that we agree to have an opinion on special town meeting warrant article 3. So if we're ready for a vote on that, or Jennifer, do you want to talk about it first?
I mean, I don't want to have more conversation than we need to. I wish that it was more close. I wish we knew, and I know we don't, and we're not going to, knew what the purpose of the purchase would be. And I understand that the purchase needs to come and then the community will have conversation about what that is, but so it feels slightly, it makes sense because we have a potential interest in being able to utilize that space or part of the space. I just wish that we sort of had a stronger understanding of whether or not, because we typically may opine, I love that you use that word, David, that we typically opine on these because there is a relation to school committee and school use. It's just, this is sort of one of those like gray areas, like we might, but we might not have any use of this space at all. I just wish it was a little bit clearer to us before we decide that we're going to make comment. But I guess we make comment and we opine on it because we hope that we will have access to that. So I guess it makes sense to speak up now.
Or Jennifer, that can be our opinion, or at least your opinion, which will become embedded in our opinion, right?
Well, what ends up happening is we're only, at this point, we are just referring to the full school committee, different warrant articles that we may want to take an opinion on. And then the full school committee will ultimately vote on that, along with a discuss. And then after the next round beyond that is to come up with statements on behalf of the school committee for each of those warrant articles. So for the acquisition of the Newbury College West parcel, we already did this exercise just last May. We already have a write-up. We could even just go ahead and redistribute that write-up. So it wouldn't really be a lot of work on our end to do that. Basically what happened was, under state law, municipality is supposed to approve of a bonding within 3 months of a townwide vote on a debt exclusion, and we weren't able to do that because the debt exclusion vote's not going to occur until November 3rd. So town meeting has to have the same vote we already had back in May because of that 90-day lapse. Mary Ellen?
Yeah, so I just thank you for reminding everybody about, we had a decision in May, we had an idea in May, and I think we're all suffering from COVID time warp, where that seems so long ago, and it seems like over a year ago, all of the discussions we had around an early childhood center and what space and how we would use it, and we were sort of going full steam ahead, and then entered time warp. So I think it is taking that May discussion and work that the capital subcommittee did and the school committee did, and dusting it off, and at least saying, this is what we were thinking the last time we had an opportunity to think about it, because we've been distracted with other priorities. So that, and then also, because it does feel like a larger span of time than we were expecting for this purchase to actually get approved or even considered at town meeting.
That would be great if we could bring that, if we could find the statement that we made, that we put towards town meeting. I know, I'm sure we can find it, but if we could put that forth when we do this, and then, that would be interesting to sort of revisit it and see if we're feeling the same way, knowing what we know now about how things have affected us with the pandemic. Anyways, that would be good. I think that would be useful. And I'm ready for a vote, David.
All right, so Jennifer?
Yes.
Andy?
Yes.
I also vote yes. All right, moving on to the next warrant article. So town meeting warrant article 6 addresses body cameras and in-car videos for police. Now, Jennifer, you probably remember this, but the previous chair of the policy subcommittee, to him it was very important that school committee take a position on it because of the impact law enforcement can have on our students. There was a bit of a debate we had at the full school committee level about whether we should delve into any subject that could touch upon the students. And the person who articulated that position was worried that then we would end up making statements on absolutely everything, because students are a part of Brookline as a whole. And so everything is going to affect students one way or another. Mary Ellen, I see you want to say something on it? Or?
No, I was saying goodbye to Casey. I just caught with the hand wave.
All right.
Being polite to my colleagues.
Jennifer?
Yeah, and I think that I do remember this extensive conversation that we had both at the subcommittee level and the full school committee level, and that particular warrant article, sounds a little bit different than this one. It was that was on like face recognition surveillance, and this is may or may not have overlap clearly, but may or may not be exactly the same argument. I need to read the warrant article more to see if this is something that would affect our students. I mean, I guess when they're off campus, but I think we were saying that we would opine on it because there was a potential for it to affect students on our campuses or walking amongst our campuses, particularly the high school. And maybe that's still the case. I don't know. I need to know more about the specifics. Do you have a sense, David, from the language of the warrant article, whether or not this is something that, is it just on body cams? Is that what, there was another piece.
No, it's body cameras as well as having cameras within the police vehicle. So there's Mary Ellen, to what extent are police officers within the schools? And does that happen on a regular basis?
Oh yeah, all the time.
All right, in that case, it probably is relevant. If we have police inside the schools and this warrant article is asking that they always have their body cameras on, then that probably is something we should take up.
Yeah, I mean, there would need, now that I think about it, we have 7 or 8 resource officers. They are in and around the high school. They get called into schools. We ourselves as a school district need permission to videotape. The police aren't in there for criminal, they shouldn't be arriving for criminal. That's part of the concern around having police in schools is What is their role there? Why are they there? Some districts, police officers that enter schools have to literally by department policy would have to leave their, not only the camera, but their weapons also in their locked in their cars and not actually be armed. Because technically you cannot have a firearm on school property unless the superintendent gives authorization or permission. So some police departments respect that and leave their belts in the cars because they're there on a friendly basis. And some of that attitude has changed. So I think there is a question about what happens to those cameras when they enter a school. Are they on? Are they off? If they are on, when are they on? So if they're called because of a threat or some 911, are they on? But if they're there because they're doing community policing and support and SRO work, then are they on? Are they not on? That is I have not heard that part of the expectation of the police department. I don't know if it's in the warrant or has been addressed, but I have not had a conversation with the police department about this at all.
Jennifer?
Could you just clarify for me, and I apologize that I am not familiar with these details, who is the author of the warrant article or authors?
Janelle O'Neill.
Okay.
Meeting member, precinct 4.
Yeah. Okay. So, I think there are definitely, I think my gut is that we probably need to find out more about it and probably opine or at least discuss whether or not we want to do that with the full school committee, because I have some privacy concerns. And if a school resource officer is coming in and they're in and they're there and they're networking with students and like cameras are on, then like, I just think that, that we don't even know who's being filmed and who's not. And like, we have to be so careful of that anyways. There's all kinds of like laws and regulation around it. I don't know. I just think that we need a closer examination of the warrant article to understand perhaps there's conversation with the warrant article author and maybe they could provide information. Maybe we need to get some information from the police department. I don't know. I just think maybe we do need to look at this if it's going to be something that happens on our property.
I agree. And the purpose of this exercise right now is not even taking a position on the substance of it, but whether or not we want the full committee to address it. So I personally think we should. Jennifer?
Yes.
Yes.
All right, so the next one that I think could be relevant is Warrant Article 12, which is for Brookline to adopt the Community Preservation Act. And the Community Preservation Act would be, at least for what's being proposed for Brookline, would be a 1% surcharge on property taxes to fund preservation of open space, rehabilitation of historic properties, recreation, and affordable housing. Now, those 4 categories are established by state statute, so we don't get to change those, but we can decide whether we want to opt in to that state law that provides state funds toward one of those 4 objectives. Now, I'm the school committee liaison on the Land Bank Committee, which is bringing forward this warrant article in terms of approving the Community Preservation Act. And during the land bank discussions, there was a little bit of a tension about whether we want to just opt into the CPA or whether we want to sort of craft our own land bank mechanism or funding mechanism for something that would be a little more school specific. Because initially, when this discussion came up for a land bank study committee, was to look for other ways that we could acquire properties to build a 9th school, for example. And it appears that the land bank committee as a whole decided more to just embrace opting into the CPA. Brookline taxes already go toward the CPA fund, but we don't end up benefiting from it because we haven't opted in. In the past, there was a vote that failed in order to opt into the CPA, but that vote would have been an increase of 3% to property taxes. This time, the aim is 1%, so perhaps the outcome will be different, we'll see. So the reason I think this could impact the schools is twofold. On the one hand, there had been that discussion I just mentioned about whether we should go our own way to finding alternative mechanisms to debt exclusion votes for acquiring property that could be used for schools. And sort of the other relevant factor is even with the CPA as written, improvements to recreational space, one of the 4 areas that is approved for funds. And so conceivably, some of that money could be used for our playgrounds. So we have an opinion as to whether we should bring this up for the full school committee.
Well, Parks and Rec takes over, addresses most of our playground space, not all of it, but a large majority, which is sort of how I see, that recreational space and open space is going to fall under Parks and Rec and not really the schools. I don't know, it's sort of tenuous. I'm not really sure that I feel strongly. I think it's a little bit tenuous. I'm just not sure what would the impact of us making a statement or not making a statement, like what value add does our statement have? Because it's not a direct schools link. It's like a sort of secondary open space Parks and Rec question and not so much a school land.
I mean, is there any prospect that this could ever help us acquire a parcel of land on which to build a 9th school? That seems like a stretch, right?
Yeah.
Right, so that's the reason I think it's potentially relevant, because when the Land Bank Study Committee initially formed, the context around that was trying to find alternative mechanisms for acquiring a property to build a 9th school that would not involve a debt exclusion. By going this route, we would be choosing as a town not to pursue that at this time. So we would be saying that we want to go with the traditional state statute, Community Preservation Act, which again is for one of 4 purposes: preservation of open space, rehabilitation of properties with a historic designation, improvements to recreation space, affordable housing. So really the one tie into schools there would be potentially with playgrounds, but as Jennifer mentions, Parks and Rec primarily deal with playgrounds. So really it's only if we would end up on the substance of the Warrant article opposing it, because we would rather that any surcharge on property taxes go toward acquiring properties for school use.
I think that's just going to be really tricky. I don't think that my read of the language right now does not really have any sort of direct benefit to the schools. And I understand that, there is a long-standing conversation about 9 schools in this town and school property. So I guess we can bring it up to the committee and see if they want to say they oppose it. I don't want to withhold anybody the opportunity to, make comment about that.
Toward your initial thoughts of actually not recommending it, because we're going to have a lot on to deal, I think realistically, to deal with anyway, and we're going to have public hearings for each one of these Warrant articles that we're going to take a position on. That can be very time consuming. So if there's something that we're on the fence on, I'm actually more inclined not to include it, especially if it doesn't directly address schools. I was just trying to provide for the 2 of you the broader context about the discussion of whether to try to opt into the CPA or forge our own way to come up with some other mechanism by which to acquire properties for school use. But in terms of the text of the Warrant article, it doesn't have any of that in there. It's just sort of a straight out, should Brookline adopt the CPA at a 1% surcharge to property tax level?
I think that's going to be I don't even think anybody is really ready in town. Well, maybe there are people that talk about more. We've already got so many projects going on between the high school and Driscoll and Pierce. Like, I can't imagine we're going to get much traction on any conversations about other land. And because the language of the Warrant article, the really only thing we could do is oppose it, say like, we'd rather you do something else. I don't think that, but that I don't even think that's really up for debate at this point. So I'm not inclined to, I don't want to stand in anyone's way, but I also don't feel strongly that we should bring it forward.
I agree with you.
I'm not thirsting to offer an opinion on this one either.
Okay. So it sounds like that one's a no. All right, next up is Warrant Article 28, which is mandatory financial literacy education for all office holders. So that's at least relevant for us as school committee members. But do we want to bring that to the attention of the full school committee? I personally think that we should, because it does mention schools. I mean, it never mentions the word school or school committee, but it does say all office holders.
Do they mean office holders like commissions and committees, or just elected officials, or everybody?
Pretty much everybody. So whether you're someone who's appointed onto a study committee, or whether you're an elected official, such as a town meeting member or advisory committee. So I think they mean anybody who's engaged in town governance.
And are they saying that people need to have, like, what would be the minimum, the expectations of, like, how does one determine financial literacy benchmarks? Like, are they saying you need to take like a course, or what are?
So this is being proposed by a former BFAC member, and I think what is in mind is something similar to the mandatory training on open meeting law. So I don't think it's some kind of big, cumbersome, involved process. It's more of, here's some basic terms you should know. You should understand what the financial implications are for major decisions. But I can't know for sure. That's just my trying to read the tea leaves. But my sense is that it would be more similar to open meeting law education.
And so are they designing it, and are they going to train everybody? Almost like, what is there a financial impact, like a budgetary impact of like trying to implement this warrant article? This is one of the interesting things that I think that there's been some conversation about things getting introduced at town meeting, and then the municipality understanding the financial impacts of the warrant articles that we pass. It's just an interesting, not relevant for us to discuss here, but I just feel like I don't know enough about what this looks like to say whether I would support it or not. Like,
I think any opinion we might give would look kind of weird. We would either be saying like, oh no, we don't need any financial education, or we'd be saying, yes, we're in dire need of financial education. Like, please give us some, right?
Well, I think it depends on what we say. So the way this has worked in the past, Andy, is we actually craft a written statement about which sort of explains why we either support the warrant article or why we oppose the warrant article. So if we take this up, we could have in our explanation, we oppose not because we don't value financial literacy, but due to the lack of definition around what that financial training would entail, and we would have liked more detail. So that can all be embedded in the statement.
So does this warrant article apply also to town meeting?
Yes.
Okay, I think that's the main place where this education might be.
Right. This is mainly geared toward town meeting as well as advisory committee, but the way it's written, it applies to all office holders.
That's pretty broad and sweeping. I just think, I don't know what the implementation looks like, and I do think that's an important part of bringing this to the floor. But
to me, at least, so that's something that we can address by having the author of the warrant article present what he has in mind. That's something that would be fleshed out later. We're running through these just in terms of what we want to refer to take an opinion on, not what that opinion will be. So we could still reject it on the substance.
Well, I think it probably is something we should bring up with the full committee so that they're aware of it, whether or not we as a committee decide, but I think probably we should bring it up as a point of information that there is a warrant article that would require.
Sorry, who is the petitioner?
Mike Toffel.
Yeah, I mean, I'm okay with bringing it to full school committee. I think even if we decide that we're not going to take an opinion on it, make a stance, I think just to make people aware that, I mean, I just don't know how you implement that. And like I guess right now I just feel like having to implement one more thing, it's like a bridge too far. Like, we need to get kids in buildings, and we need to make our spaces safe, and that's the priority. So it's hard to like sort of mentally do this practice of like, well, how does this pan out? I mean, I think that's something that the author will have to discuss with town meeting, but I do think that members of our committee should be aware that there is a potential warrant article that would impact us and our work. Although that being said, I do think financial literacy is really important, and when you manage a budget the size of the budget that we manage. It's really important to understand that. So I thank Mary Ellen for onboarding with me when I started, because that was really important. So is that just going to be yet another job for Mary Ellen to like make sure that all school committee members are financially literate? I mean, I have a lot of questions.
Well, I think we could, if we end up referring this to the full committee, we could have Mike Toffel come address us at some point, or we get a little more information on what he intends for this. But I think that to me, it's clearly relevant to us. If we're going to be required to undergo financial training, then that's relevant, and we're supposed to be taking positions on warrant articles that are relevant. So to me, I think we vote for this to be presented to the full committee. All right, so Jennifer's a yes. Andy?
Yes.
Okay. All right, so next up would be warrant article 33, which addresses the town-school partnership. This is being proposed by Arthur Conquest and a few other town meeting members, and they would like to see the number of additional stakeholders added to the conversation around town-school partnership. So that's what their warrant article does. They want to add other residents to be able to engage directly in the discussion.
I vote yes.
Yeah, that definitely.
I vote yes.
We need to bring this up.
Yeah.
The next one is warrant article 37, which is to get us paid. So stipends for school committee members. It would be $20,000 a year for the chair, $20,000 for the vice chair, $15,000 for everyone else. It would be effective starting July of 2021.
I vote yes, we bring it up.
I vote yes to bring it up.
I mean, I guess I'll go along with that just to bring it up. I mean, I have strong personal feelings on this one, but I'm not sure that the school committee should weigh in. But
right, I agree with you too, Andy, on the substance of it. But again, this is more what are we bringing to the attention of the full school committee because it has relevance to school personnel or school committee or
sure.
school governance.
Yeah, we can decide at the full committee whether or not we want to make a statement or we just let it. I mean, it's probably more appropriate for us to just not opine and let people make a decision, but I think we need to bring it up with the full committee.
Right, okay. And our last one, warrant article 39, which is a prohibition on new fossil fuel infrastructure. So as some of you might recall, the state basically overturned a warrant article that the town had passed to ban new fossil fuel infrastructure. I am fairly sure that we issued an opinion on this in May, so we could probably just bring that right back. But it's the obvious relevance to the schools is that any new school construction, unless there's a specific exception, would need to be fossil fuel free.
I mean, yeah, sure, we should probably bring it up. I mean, I think that most of our school, everything we're doing now is fossil fuel free. I mean, that's our plan. It'll hold us to it if it passes. But it does address school buildings will be part of that new construction. So we probably should.
I agree. Andy?
Yes.
All right, so that's all of the ones that I found, which is a total of 7 warrant articles, which means 7 public hearings. But what I recommend for, well, not necessarily. First of all, school committee has to agree that we want to take up these 7. Then we would have to decide what position we want to take on, along with having a public hearing. My recommendation on the public hearings, and this is something that I can take up, I'm going to check the town calendar for when various other commissions and boards and groups are having their hearings, and then maybe we can tack ourselves onto some of those for whatever school committee decides of these 7 that we want to take up. And that might help economize on time at minimum for members of the public, so that there's not sort of just a repeat of presentations and having the same meeting multiple times.
Yeah, I think that just might be a little bit tricky. So, I mean, just in that I don't think any other group is going to want to pick, say, these 7 or some subset of these. And so we'd sort of have to be parsing out and saying like, oh, well, this other group is going to take up Article 37 or whatever, I'm making up numbers, 37. And so we'll also have our hearing at the same time. And then this group is going to do 32. And I don't know. We could also just do one public hearing and say, we're going to have a public hearing on, well, I don't know. I don't know if we can do this. I think we can do this. Just have all of them and people come and speak and on all, like any one of the warrant articles they want to.
So I think that could be an option, but just, so for example, the Newbury one, the select board is probably going to have a public hearing on that. And there will probably be maybe hundreds who want to talk about Newbury. And I'm worried that if we included Newbury with our other 6, we're going to have the whole meeting tied up with people speaking about Newbury when we could just have a quorum of school committees show up to that select board meeting. And then we get through our statutory requirement that way. So I'm thinking more along the lines of maybe a mix. So what you suggested for maybe 3, 4, or 5 of them, whatever it might be. But if it's a particularly popular warrant article that a lot of people are going to want to focus on, we might be better off tacking on to somebody else's.
No, I agree. And we've done that before with the select board. We've had joint public hearings before with the select board. I think especially on like Newbury, any of the large issues. Yes, I agree.
Okay.
Yeah, I think it's important really to economize on our time just because there's so much that we have to deal with right now and we'll continue to up until town meeting.
Right. So moving on to our next item, and we can try to move through this quickly because, oh, sorry.
Do you need me? I need to jump off to another obligation.
All
right, have a good night.
You too.
Thank
Bye.
you.
All right, so we're coming up on 7 o'clock, so I'm going to try to, hopefully we can move through this part a little quickly. We can always include this on our agenda for the next meeting as well. But a discussion of 2020-21 policy goals for the committee. So I received an email from a member of the public, Ms. Donna Perry, and she had a lengthy list of policies she would like to see us cover. And I think that her choices were quite on target. So these are policies I would like to see us address as well. So I'll just run through those quickly just to mention them. So she listed professional development, mission statements for policy subcommittee, administration's reports to school committee, physical restraints, specifically seclusion, timeouts, training and complaints, reporting of suspected child abuse and neglect, part-time and sub-staffing, suspension and evaluation of personnel, mission statement for evaluation of administrators, teacher evaluations, criteria and format, material, having trouble reading my own handwriting here, material selection and evaluation, curriculum development, student grouping and inclusion, bullying prevention, code of conduct, in-school observation of special education policies by parents and guardians. And those are all existing policies we already have. And Ms. Perry is recommending that we take a look at them and revise them. So from that list, do either of you have thoughts about policies that are particularly important to you?
Andy, I feel like I've been jumping in like way too. I've heard my voice too much. Would you like to go first, or do you want thinking time?
I would like thinking time, yeah. Also, I think before weighing in on that, I would need to go and look at the existing policies that Donna is referring to see what I think of those. I guess I would like to take an overall look at policies affecting special education and see whether we can, whether it's worth trying to sort of codify certain things that currently aren't codified or where we rely on state and federal law. There might be areas where it would be good to just have a kind of unified policy that would sort of tell people what they need to do in certain situations and make it clear what is district policy, what is state law, what is federal law. That's a sort of bigger project. As I happen to be the school committee's liaison to CPAC, so I could try to talk with membership of CPAC and leadership of CPAC as well as some of our district staff, try to figure out what are areas where like a written policy might help people with their work or with issues they want to raise. I don't know what the answer will be, whether it is the case that codification would help. But it just seems like it's so hard to find your way in this thicket of laws and regulations. There might be some value in us kind of clarifying that for everybody.
Well, I agree with you, Andy. And also special education in particular is quite a challenge right now during these times of remote learning academy. And I know that there are many special education students who are already in the buildings, part of that first to return cohort, but not all. And we need to make sure that all of our special education students are receiving the services to which they are federally entitled, and hopefully beyond that. As a member of the public had mentioned earlier, if we can go beyond minimum requirements, that's something that should be explored. I certainly would be supportive of going well beyond the minimum whenever it's feasible.
I agree. I think that there's a number of policies that you mentioned, David, that are specifically addressing special education population of students. I think that would be a good place to start. I did like the idea of, and I think maybe the second one you mentioned was a mission statement. I think that's a really nice starting point. Having some goals and a mission statement. Hopefully that would be something that we could do. I don't even know what our existing one is. I do think, especially in this, I think on any given year, we probably could go through our special education policies and look at them. I think that's right now, especially amidst the continuing conversation about whether or not we need a special education committee, subcommittee rather, or what that work looks like. I think that what we can do as a committee is look at the policies until that piece gets sort of figured out or sorted out. And the remote learning environment that we have right now, we're Remote Plus or RLA. There are a number of concerns right now with not only with the model, but the staffing that we have. We have students without special educators right now who are not receiving services. And so I think that, to be really clear about our policies so that we can be communicating that with staff and making sure that procedures and protocols are being followed in compliance with our policies, and deciding when we might need to expand a policy or combine policies or create a new policy based on the experiences of our students and staff would be helpful. So I do think that would be, in general, I'll say special education would be a good focus. I think we've dealt with some of the remote learning policies early this year. If we wrap up immunization, that's sort of one of the outlier pieces of the remote. Special education is an area that we could do a lot of work on, I think.
Okay.
But I also, this is a list of these are sort of someone else's goals, right? That we're talking about. And I think that those are important. I'm not sure that we would get through all of those. That was a very long list, and we are not known for getting through that many policies in a year. I certainly don't want us to get through as few as we have in the past. We've already done more in September than some times in a year. So that's exciting. And I'd like to see us, we've done a pretty good pace this calendar year with policies. So I just want us to be mindful of other policies that might need our attention. And not to just be doing, one area. Does that make sense? Like, I think we could tackle some special education, but there might be other pockets like, I think student activities is on hold for now because we're not doing student activities really because of the remote model, but that was something that was urgent at the time and perhaps is no longer as urgent as some of these policies. But I think we just need to be mindful that there might be other areas for our goals long-term for the year we need to focus on.
I agree. And are there any, so you mentioned student activities. Are there any others that come to mind for you that we should add to this list, at least for purposes of just sort of a homework assignment for the three of us to read them, be familiar with them so that we have a better idea of what we want to prioritize?
No, I mentioned student activities because it's one of the outliers that we've, in my several years, we've not been able to do for a number of reasons. I think also on there was our policy for code of conduct and our bullying policy, which we just went through. And so I guess I would maybe give preference to policies that have not been recently reviewed and may be in need of an update that is, I've seen dates in the policy manual, not in this section specifically, but, from the 80s and like early 90s. So I guess one of my goals has been for us to like update the entire manual. And so I guess I would give some slight preference to things that have not been updated in 20 or more years.
And to that point, there was a lot of work that had actually been done toward updating the chapter on finance. I know that's somewhat less pressing right now. That happened before, just as the pandemic was beginning, but the work was actually already done in terms of going through that draft. So I think that's something we can bring up at a future meeting, because we already have it kind of sitting there for us to go over and see what changes we agree to, and we could discuss those proposed revisions. Now we have a question from a member of the public, Ms. Connie Clausen, who is asking if we have sought input from the elected leaders of Brookline CPAC prior to this discussion. So Ms. Clausen, to at least address your question, Andy had asked that to me, that he wanted to know specifically which policies would pertain to special education, so that he could have that discussion with CPAC, because he's the school committee liaison to CPAC. I'm quite confident that he'll have that discussion with them. I can also tell you that maybe about 3 weeks ago, I don't recall exactly, I had some email exchanges with one of the CPAC co-chairs about what would be some priorities for CPAC for us to look into this year. Received a very thoughtful response. So we certainly are very interested in communicating with CPAC and hearing what their priorities will be. Just because we're having this discussion right now does not by any means preclude them from participating at a future meeting or from writing to any of us what their thoughts are. This is really a preliminary discussion about policies that we want to look into for the year, and we will continue to have this discussion at our meetings. There's really no reason why someone can't propose at any of our meetings a policy that they would like us to look at. And speaking of that, I am recalling that you recently sent me an email about us adding a yearbook policy. And I believe that your precise language was that it could even be as short as one sentence, the yearbook policy, that could be all students enrolled in a PSB school at any time during an academic year shall be included in the school yearbook for that school if one is published for their grade. And you had explained that the importance of us having a yearbook policy, especially now during these challenging times of the pandemic, is to make sure that all our students feel included and that they are part of a community and that they are known and they are immortalized by having their presence in a yearbook. That's a concern that I share. It sort of speaks to the social emotional aspect of public education. So I certainly would endorse that we look into adding a yearbook policy. I think that the language you propose is excellent. We might tinker with it a little bit, of course, but I do think this is something that we will take up. I can assure you, in fact, that I'll have that on the agenda and we'll have further discussions on it. Jennifer, Andy, would you like to address Ms. Clausen's question?
I would just say that this isn't a special education discussion right now. This is a discussion of goals of the committee. I'm just looking at the comments here, and this is our goals. This is a goals conversation, and for me, it's not yet which policies or which to review or who's to review. This is about what are the goals of this committee and what is the work that we think that we can tackle this year, so that we can keep ourselves on course as best we can and making progress on reviewing the goals. So I guess to sort of restate my goals, my vision, I would love for us to do the whole book or a section of the book, of the policy manual. I don't think that we'll be able to do that. I also sort of prefer a systematic approach where we may take a section where some of these may live and go through the section, and then we'd have an updated section of our policy manual. David, to your point, there were a whole bunch of financial policies that we had been at work on, and those may be, that may be some work we can take up this year, especially if it's sort of a discrete section. Special education, which we haven't in the last few years spent as much time on, and so it might be an appropriate time for us to begin some of that work. You know, and then there's always things that come up when, you know, we have new issues that have to come up. So I'm always interested to hear what members of the public are interested in. Sometimes we hear from staff that there are things that they need us to do. You know, so I think it's a good conversation to begin thinking about what our goals are and what we aim to accomplish this year.
Okay, and I see we have another member of the public, Miss Lucy Florman. Did you want to provide any input on anything that we have discussed this evening? No? All right. And anything under new business?
But before we leave this, so my purpose in bringing up special education was just to get a sense of the rest of the subcommittee. Should I go ahead and, you know, have these conversations with the CPAC leadership, and also I guess there's a CPAC meeting actually later this week. Where I'm supposed to give an update from school committee. Can I mention that this is going to be something that we look into as a subcommittee and try to systematize a few things and codify things, you know, and that we want the community's input on, you know, where this could be most useful.
Yes, I would agree to that. How about you, Jennifer?
Yeah, I think it would be great to get some input. I mean, I think we can, like a starting point would be the existing policy manual. And then if we find that among those policies, they cannot be modified to incorporate the concerns or the unaddressed needs, that we could consider creating new policies. Mm-hmm. But I think that reviewing what we have and seeing if it's appropriate would be a really good starting point. I mean, if folks are interested in sort of like what the work of that is, you know, their policy manuals published on our website, and people can take a look at that and provide feedback about, you know, specific areas. Yeah, I mean, I think that's great. Outreach is great. You know, the more people that we have, you know, the more brains are better. So yeah, I think that's great.
Okay.
All right, so anything under new business? All right, then in that case, I think that concludes the festivities for this evening, and we will resume again next month. I'll put together an agenda as different draft policies start to come in, because we farmed out a couple of them. There are a few that I'll work on myself, so I think that the next meeting will be able to dedicate toward looking over some specific language. All right,
David, can you just refresh my brain? Do we have a set of policy meetings set out for the year?
We do.
Okay, then it's in my calendar. That's good. If I got a list, I put them in, they're in, we're good. I just couldn't remember.
They've at least been posted on the town calendar. I'm not sure if an email went out yet, sort of listing all of them, but they are on the town calendar.
Okay.
Basically, it's every second Monday of the month at 5 o'clock.
Oh yeah, so our next meeting is November 9th then? That's, yep. Okay.
All right, so that concludes our meeting for this evening. Thank you very much, everyone who participated.
Thank you. Thanks.